Hello, guys. My name is Deborah Obiyo. I'm a legal practitioner based in Lagos, Nigeria. I've been doing this for close to a decade now. And just like the caption says, what I want us to talk about today is about the legality or illegality of phone call recording in Nigeria. Is it legal? Is it not legal? Must you get consent? Must you not get consent? You know, actually, it's just so, should I say, it's that painful that Nigerians just I don't know if it's they go to ChatGPT to type one or two things and get the answer and start blabbing, but we'll go into all that. What prompted this video was the matter between D1 and VDM, where D1 was complaining that a senior advocate sent a phone call recording to VDM. I'm not going to that the nitty-gritty of D1 versus VDM. What we want to talk about today, which touches every Nigerian, is about the legality or illegality of recording phone calls. It touches everybody. In your home, I mean in your home, I mean in your between business partners, simple contracts. Is it in every case you should get consent? And the funny thing is, this thing is spelled out in the law. And unfortunately, it's so sad to see that even lawyers don't get it right. So the essence of this video is to put this matter to rest. That is the essence of this video. I'm going to walk you through the major legislations that um, dwells on this issue. I'm going to even talk about the other legislation that's been imported by people or ChatGPT because I made my research and I saw that okay, everybody's just getting the answer from ChatGPT. I'm going to address that issue. Meanwhile, please subscribe to this video, encourage me, click the subscribe button, like this video. Thank you, thank you, thank you. Now, what does the law say? Everybody, one thing you should know as a citizen of Nigeria is the constitution is the ground norm, is the father, the grandfather, and the ancestor of all laws. Understand that there are so many other laws, but any of these all other laws that is in conflict with the constitution, that law is null and void. So the beginning of everything is the Nigerian Constitution 1999 as amended. And now, the section that relates to the privacy of persons, personal life issues is section 37. And what does section 37 say? It says the privacy of citizens, their homes, correspondence, telephone conversations, and telegraphic communications is hereby guaranteed and protected. Capiche? Your rights, every other person's right to the sanctity of their home, to the privacy of their affairs, of their correspondences, letters, memos, telephone conversations, telegraphic communications, videos, is protected and guaranteed. But one thing people don't know is these rights, or they know, they claim not to know, or they claim not to accept, or whatever it is, these rights are limited. Your right stops here, and that is where another person's right starts. That you have a right to the privacy of your home does not mean that police cannot come and arrest you inside your home, break into your home and arrest you. We can't go into that law now. There's the ACJL and the ACJA that speaks to that. Your right stops where your nose ends. And that is where another person's right starts from. And that is where the right of the state starts from. No right is all inclusive. There are limitations. And that applies to this right to correspondences, right to your home, right to telephone conversations. Now let's delve into the the second legislation. The second legislation, I would have talked about the Nigerian Data Protection Act of 2023. The act is it is the main act when you want to talk about protection of data. Remember, phone recording is data. It is information. Is it personal data? Yes. The voice of a person can be used to recognize that person. It is personal data. It is personal data. The Nigerian Data Protection Act gives the basic rules, legislation, clauses, but when you go to, for the purpose of this video, not to make it too long, for the purpose of this video, we are going straight to the Nigerian Data Protection Regulation. They are always acts, and the acts, which is like the major law on that subject matter, has the power. There's a clause in that act that has the power to create regulations. There are subsequent regulations. For example, CBN, if some of you follow, you see that CBN makes policies, regulation. You have to follow back to back. You can't always be referring to the CBN Act, CBN Act, CBN Act, because the Act needs the House of Assembly, the National House of Assembly to do the whole process. But the Act empowers these bodies. The act empowers the body responsible, that's in this case the Nigerian Data Protection Commission, to make regulations. As time goes by, as things develop, they can make regulations. So let's go to the regulation, and we're going to Regulation 2.2. You can get this online. It is available. It was done by NITDA. Regulation 2.2, the heading says lawful processing. And I read, without prejudice to the principles set out in this regulation, processing shall be lawful if at least one of the following applies. There are 5 instances, and we'll read them all. 1, the data subject has given consent to the processing of his or her personal data for one or more specific purpose. Where you are getting consent, where it is necessary to get consent. There are situations where consent is necessary. That's the beauty of law, and that is why we lawyers are here to help you. There are situations that consent must be obtained. Example, I can throw in a few examples. MTN, NCC, should I say NBA? Let me bring in my profession. Recently, they did something. They asked us for consent. Should we give your information out? You get? There are so many places where consent must be obtained. There is no two ways about it. Then, in the second instance is where processing is necessary for the performance of a contract, to which the data subject, that's the person you are recording. In this case, you are recording him, you are processing his voice, you are processing his personal data, his voice. That's his data subject, to which the data subject is party, or in order to take steps at the request of the data subject prior to entering a contract. If you're doing a business with someone, please record. Record. You are allowed to record and not get consent. You are allowed to record and not get consent. This is business you're talking about. This is money. This is terms and conditions you're talking about. You are allowed to record. Processing, the third condition, processing is necessary for compliance with a legal obligation to which the controller is the subject. The controller is the subject. I am the data controller. In that case, I'm the one recording. And I'm doing it to comply with a legal obligation. Example, I think there's a KYC in Anambra State now that demands that president generals of communities must have a database of all the tenants in their communities. That is a legal obligation. The President General is complying by going from house to house to meet the landlords to get the data of every tenant in that house. There is a legal obligation. There are so many instances. So many. You go to the bank, there is a legal obligation for the bank to take your information. They have to comply. They are the data, the bank is the data controller. They have to comply. They don't need your consent. There are some information. You went to the bank to open an account. You are saying you must obtain my consent before I give you my information. The fourth condition is processing is necessary. This is the ultimate. Do you know why I say this thing? Let me digress a bit. Why I say this is because I keep record. I can't, and when I say I keep record, I don't mean I keep record of every call that comes into my phone. That would be crazy if I did that. But for me as a human being to decide that there is a need for me to have a recording of this conversation, then there is something there. There was something there. I didn't wake up one morning and start recording people. No. And this is where protects me and every Nigerian. It says, processing is necessary in order to protect the vital interests of the data subject or of another natural person. What else? You are recording something to have your own interest, to protect your own interests. There is no illegality. You are recording something to have the interest of the data subject. There is no illegality. You know, I was telling somebody, something happened recently somewhere, and I was telling someone, them say they did not say, amongst a midst of group of friends, come here. What there's this Alvin post that said if you have a group of friends that nobody is asking you, come here. What did you tell this person that I said that this person said that you should thank your God? And I was telling this person, it's better you play my recording of what I said, so that there are nuances that are attached to the way somebody talks. Unlike a reported speech, some people can report what they understand from what you said. Some people can report exactly what you said, but with not with the right emotions, not with the right nuances. So I would prefer record me. I have nothing to hide. I'm a legal practitioner. Integrity is my watchword. Record me and play my recording anyway. It is better than saying Debbie said she did not say, she said it like this, she did not mean it like this, and then a third party is having issues. So back to this fourth um, condition. If you are going to, if you know you want to protect your interest, if you know you want to protect the interest of the data person, please record. You don't need consent, but we are going somewhere. The fifth condition is processing is necessary for the performance of a task carried out in the public interest. COVID-19. Who were the people that were in this hospital? Maybe there was there was an outbreak in the hospital, and then they find out all the information of people that visited that hospital during that period. Go to their houses and get them, quarantine them. Yes, that's what he's saying. Public interest or in the exercise of official public mandate vested in the controller. Official public mandates. All these regulatory bodies, they have mandates to do certain things. So the Constitution guarantees your right to correspondence, privacy of life, privacy of telephone conversations, but there are exceptions. There are exceptions. I believe this is clear to everybody. If you go to the following regulation of regulation 2.3, you will see the process for obtaining consent, where I believe I gave an example of people that need to get consent. Those people that need to get consent, the way they are supposed to get the consent. There was somebody I told one day, you have CCTV camera in your office and certain number of people come into your establishment and you don't have a notice of you're being recorded, there's a CCTV. These things, there are laws to these things. You have a website, you don't have a privacy policy. Let them not catch you. Let them not catch you. That's unfortunately Nigeria. But we all should be legal compliant. I digress. So now we have seen it is in the law. Please take time and find this. Don't ask ChatGPT. Go to the law. Nigerian Data Protection Regulation. Read it. Just clause 2.2, you will see it. You can read 2.3 and you will see it. You don't need consent of the other person to record. However, what did I say? However, it is how you use it that matters. It is how you use it that is the problem. Record o, but don't use it anyhow. And let me say categorically here that there is no law in Nigeria that criminalizes recording of phone call conversation. There is none. Please, if anywhere you are, they bring up this topic, tell them to tell you, please show me where the law said nobody shall record the phone call of another person. If you breach this, you shall go to 10 years imprisonment or option of fine of 10 million naira. That is how it's always drafted. The law and the punishment. The breach, the law, the breach, and the punishment. There is no law that criminalizes it. But there are laws that criminalizes how you use it. And that is where people bring in the Cybercrime Act, the Cybercrime Prevention and Prohibition Act 2015. You know, when people mentioned 37 of that act, section 37 of that act, I wondered, let's quickly go that way before we go to where I believe is relevant. Section 37, that's what ChatGPT will tell you. Please read it. Don't believe ChatGPT at all times, please. It's talking about duties of financial institution. How does it concern us that we are talking about our personal lives and recording conversations? A financial institution shall verify the identity of its customers carrying out electronic financial transactions by requiring the customers to present documents bearing their names, addresses, other relevant information before issuance of ATM cards, credit cards, debit cards, and other related electronic devices. It's just a lot. This is not relevant to day-to-day life, business, contract in your home. There are even exceptions. You can record in your home. There is a lot. The topic is broad. But what we are here to answer today, it is not illegal to record phone call conversations. What is illegal is how you use it. And now let's go to the Cybercrime Act, section 24. Section 24 says, it's talking about cyber stalking. Of course, if we are on the internet, you are conversant with this. It says, any person who knowingly is the words, that's why I love law, knowingly or intentionally sends a message or other matter by means of computer system, including your phone or network, that one is grossly offensive. There is no reason for you to send out something. You are sending it out. It is offensive. It is pornographic. It is of an indecent, obscene, menacing character, or causes any such message to be sent, to be so sent. You cause a message, you facilitate a message to be sent out. Even if you sent it to somebody and the person sent it to another person, me as a lawyer, I will sue all of you in that line. It's not a matter of, it's not me that sent it. Of course, Bobrisky's case, that other guy sent to VDM, all of them should be in the case. So the second condition is, you know it to be false. You know it's a lie. Probably after recording it, you went to edit it. You went to tamper with it. You know it is a lie. Or it is for the purpose of causing annoyance. You just want to make somebody angry. Because there's no relevance, there's no importance, there's no need for you to release that recording. You just released it to make somebody angry, to make somebody agitated, to blackmail somebody. There is no onus. You are not protecting your interests. You are not releasing it to protect your own interests. You just release it to cause annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation. Black, like I mentioned, blackmail. Enmity, you release it to a third party to create enmity between two people. You have no interest to protect in it. You just release it like that. Ill will or needless anxiety to another or causes such a message to be sent, whether you're the one that sent it or you are the one that caused it to be sent, you are going in for it. And like what I told you about laws that prescribe the law, the breach of it, and the punishment. Listen, commits an offense after the first two condition. That person commits an offense under this act and shall be liable on conviction to a fine of not more than 7 million naira or imprisonment for a term of not more than 3 years or to both such fine and imprisonment. Did you see it? This place did not talk about if you record it, you are liable to the no. It is when you send it out, when you use it in a way that is inconsistent with the first regulation, the regulation we read. You did not get consent. You did not process, you didn't get it in compliance with legal obligation. It's not that it's legal obligation you are fulfilling. It is not that you are protecting your interest. It is not that your any law, any statute empowered you to collect that information. Nothing. You just record somebody and send it out to cause problem. That is where the problem is. But to record call conversations, it is not illegal. What are you using it for? What is the purpose? What is the aim? In Gonga's case, Balthazar, he recorded himself. He recorded the woman. There was no issue. Will you come and sue him for recording? No. Because the woman cannot say, they know. You can impute consent in it. The issue is when it was released, assuming somebody else. We heard that it was the government that did it. Well, they can sue the government. Yes, they can do that. For release, that's a breach of his constitutional right if it was in a Nigerian scenario. That's a breach of his constitutional rights. There's no problem with him recording it. That's his personal life. It is guaranteed. But where another person enter his home, they have the right to enter his home. The agency that arrested him, let's assume they have the right to enter his home to arrest him. But to release he should sue them. In Nigerian law, he can sue them because releasing that caused all this that we just read. It caused mockery. It caused enmity, hatred, ill will, obscene, menacing character, offensive, pornographic. It is how you use it that matters. And that is where this Cybercrime Prevention and Prohibition Act of 2015 comes in. So I believe I have been able to assuage and put to rest this confusion, because I even saw on there's a law firm in Ikoyi that even interviewed that said it is illegal to record phone call conversations. They made a post about it on their Instagram, and I was disappointed. These are part of the issues that made me to do this video. We as Nigerians, we need to sit up. The law is not hard. You can fetch out the law. If you don't know, have a friend, a lawyer friend. It is important to have a lawyer friend. Ask this question. A brilliant lawyer. A brilliant lawyer friend. A smart one. Please, record phone call conversations where you deem it necessary. But don't use it anyhow. Don't use it anyhow. I record phone call conversations where I feel there is a rising need to do so. I screenshot chats where I feel there's a rising need to do so. But when the event dissipates, I delete them. Where the fear I had did not happen, I delete them. I don't use them anyhow. And I protect them with my life that they don't get out of my phone. So please, let this end. The issue is in the using, not in the recording. The issue is in the disseminating, the sharing, how you use it, and not in the recording. Thank Thank you very much. That brings us to the end of this discussion. Please subscribe to encourage me to bring more enlightening news, to discuss more topics with you all. Thank you very much and have a blessed weekend.